So the first part of it is deal structuring. Okay. So deal structuring is very important. So let's say one company is buying another company, an acquisition, or two companies are going to merge, like a merger. What it's called, mergers are rather rare. We don't see too many mergers in India, but we see a lot of acquisitions. And whether it's an investment transaction, whether it is a joint venture, whatever, there will be some deal structuring that happens. This is where it all starts, right? So there are the obviously the companies or the parties themselves are involved. There would be also an investment banker usually. So investment bankers will be part of this deal structuring process, and there will be very senior lawyers usually. They sit together and create a structure of a deal. So what is deal structuring? What could be? I'll give you a basic idea of what deal structuring may look like. So let's say LawSikho is a company, right? So we are a private limited company, and let's say a bigger company decides that they're interested in investing in us, or they want to buy out a stake in LawSikho. So what will they do? So they have multiple choices. One choice, one structure they can adopt is that they can decide to buy shares from the existing promoters. So LawSikho has certain shareholders. I am one of the shareholders. There are other shareholders, and they might decide that we want to acquire 51% or 60% or 25% or 100%, 90%, depends on what are the commercial interests and what makes sense at that time. And they want to acquire that many. So two things can be done. One is that who is selling? Like, is the share being sold by the company? So one option, let's say they want to acquire 51% of the company. So one option is that the company issues new shares. So let's say the company so far has 100 shares, and they decide to launch 100 more shares or 101 shares. Okay. And these shares are subscribed by the acquiring party, acquiring company or investor, whoever, right? So then they will have 51% stake, or 102 shares will have 51% stake in the company. Exactly, right? So this is deal structuring. So whether they going to buy 51% from the existing shareholders, or is the company going to issue new shares, so many new shares to this company, so that they become owner of 51% share. Now this is two options, but there are many more other options also. It can be a mix of both, that some shares are being sold by the shareholder, some is being shared by the company, some shares are being issued by the company. Why does it matter? It matters a lot because, if the promoters are selling shares, then the money is going to the promoters, not into the company. But when the company is issuing shares, then the money that is being used to buy the shares, it will go into the company's book, right? It will go into the company's bank account, and it can then be further used to grow the company. So it's more like an investment in that case, right? And that money will be used going forward by the company for its growth or so on. Maybe to pay off debt, depends, right? Sometimes, rather than buying shares of a company, the other side may buy the business lump sum. Like, so for example, let's say there's a factory and it just buys the factory, or maybe it just buys out all the businesses. So it buys out all the IP, all the, in case of LawSikho, it will be courses and websites, and they just take everything on as a lump sum, as pays a lump sum amount for all the business, and it's called a slump sale. And then they can buy that as an ongoing concern, but does not buy any of the shares. The company sells all this business, and the company remains an empty shell essentially, or maybe some part of the business remains with the corporate entity that was there, and the actual productive resources are transferred to the new owner. So that is also one kind of business, one kind of transaction, right? And then there are other aspects to this as well. So for example, what kind of shares are going to be issued? Is this going to be common stock of the company? Is it going to be some kind of preference shares? Will it be a convertible debenture, right? So it's a loan right now, but later on it can be converted. It can be a compulsorily convertible debenture. It can be a optionally convertible debenture. It can have some special rights with respect to, say, certain kind of uh, dividends, etc., right? Or exit preferences and so on, right? So there can be all these kind of special rights attached to a share, liquidity preference and so on. Okay, so so basically all these things are there, and then there are other issues in structuring also, right? Other issues in structuring could be that when the investor, let's say it's a foreign investor, they are investing in Indian company, are they going to do it through an Indian entity, or are they going to do it through a entity which is in Singapore or Mauritius? Mauritius route is closed now, but let's say somewhere else, which is a more tax-friendly jurisdiction. Sometimes these things come into picture. Now, why would a company or an investor or an acquirer would look at different kind of structure? So there are different considerations, right? Sometimes the stamp duty that is payable can be taken into account, or the taxation angle is very important. So there are always tax lawyers advising at the deal structuring stage that what will be the most tax efficient method of doing this transaction, right? So that is taken into account. There are other things like commercial interests are also there. So investment bankers may weigh in, and obviously the parties have their opinion as to how they want to do it, what do they prefer. So the deal structuring, and then the lawyer places it saying that yes, this structure is good, and then the deal structure is finalized. Now, as a junior lawyer, you don't do deal structuring. It's highly unlikely, right? Unless it's a very small deal, and I don't know, like very unlikely situation that you'll be doing the structuring of the deal. But it is very important for you to understand deal structuring. Why? Because the work you'll do next, which is due diligence, compliance, negotiation, drafting the agreement, everything depends on how the deal is structured. So depending on if the deal is structured in a different way, then the documents you draft will be different. The way you do due diligence may be different. So for example, if you are doing a due diligence into a company and you're buying only 10% stake or 5% stake, you may not go in so much into certain details. But when you are doing an investment, or you're buying out the entire company, like 100% buyout or 51% you're buying out, then the level of scrutiny is likely to be much higher during due diligence. Certain things you look into in that case, which otherwise you may not have looked into, right? If you are doing slump sale, then certain due diligence is unnecessary. You may not actually do those things, but there are other things you'll be looking at more carefully. So these things are very important to understand, that why you are structuring a deal in a certain way, right? So it's quite important to understand how you're going to do the work later on.